Moving on with our next speaker, we are pleased to welcome Mr. Sameep Khanal, a Nepalese qualified lawyer with extensive experience in project finance, international arbitration, and foreign investment advisory. He has represented clients in high value arbitration under UNCITRAL and ICC rules and has played a key role in landmark infrastructure financing deals, including US 1.8 billion, Arun 3, and USD 453 million upper Trishul 1 hydropower projects. Mr. Khanal also serves as the editor in chief of the Transnational Law and Policy Review and has contributed to legal education and policy reforms through his work with the Center for International Law, Nepal. Currently pursuing his LLM in Geneva Center for International Dispute Settlement, he brings a dynamic and globally informed perspective. We are honored to welcome Mr. Sameep Khanal to share his insights on the ADR landscape in Nepal and to contribute to the richness of today's discussion. It's up to you, sir.
Hello. So thank you for this very detailed introduction. So hi everyone. So I'm Sameep as introduced. So I know every one of you are thinking like why I'm listening to Nepal at these late hours and like what Nepal has to offer. But certainly I think like Nepal has some perspective to provide. And I'm sure for India and our neighboring countries, like the practice in Nepal has many implications. So, which I will show in my slide because there are a couple of case laws that transgress boundaries and like that affects not just Nepal but also India. And there are a lot of recent changes that builds on the global practices like the issues of corruption in arbitration, like the issue of fact finding in corruption. Those issues like those are discussed not just in a minnow country like Nepal but also across Paris, Geneva, and London. And I think those changes are also like introduced recently in Nepalese legislation, which I'm sure I think this ADR Global South Day will certainly benefit from. So to the next slide, please. Yeah, so in this presentation, I'll try to be as brief as possible due to the constraint of time. And since Nepalese arbitration regime is as vast as it may seem, so we just have limited time. So I'll just try to give a good perspective so that it resonates with the ADR Day and the Global South perspective. So I'll basically try to cover the Nepalese arbitration landscape, and then I'll try to so the basic high level introduction to arbitration legislation, that is Arbitration Act 1999. And then I'll discuss the recent reforms and the recent, or should I say, notable case laws on arbitration, in which I'll try to highlight some of the good ones and some of the bad one decision that Nepalese Supreme Court has enacted, and which has implications on the practice across Nepal as well as in international arbitration across borders. And then I will try to give a high level suggestion like what could be the suggestion that can be incorporated to make it more innovative, make it more practical in terms of cross border settlement of international dispute by arbitration. So starting with the next slide, where I'll try to just introduce to the Nepalese arbitration landscape. Can we go to the next slide? So just to introduce, so Nepalese arbitration is not just focused on the commercial arbitration or not just to the institutional or ad hoc arbitration. So Nepalese arbitration dates back to a long time where we have a rich history of being party to exit conventions. And like when exit convention was introduced, Nepal was one of the earliest signatory to that convention. And then like a lot of countries in South Asia, so we are also party to the New York Convention. In New York Convention, we have a typical reservation in place, that is one the reciprocity reservation and one the commercial reservation. And why I say this is because this has come to haunt the international settlement of dispute between Nepal and India, which I will show through a case law in the later part. And then like quite surprisingly, Nepal has only faced one investment dispute so far. And in that dispute, like the GSADRT telecommunication operator basically claimed there was a breach of fair and equitable treatment by Nepalese government when assessing the tax, and they deemed that those tax were not like in line with what they legitimately expected from the investment that they undertook in Nepal. And a three-member tribunal unanimously held that Nepal did not breach the fair and equitable treatment standard under the UK Nepal BIT. So far that's the only case, and in that case, unanimously the tribunal has upheld the Nepalese defense. And since that, what has transpired is that Nepal has itself enacted a model BIT. So that model BIT, like all the model BIT across the world and in global South these days, even in Africa. So what is the trend is now the model BIT tries to make a draft which is as loaded and as biased in favor of state as possible, which I think is not the right trend. Of course, the state protection and investor protection should go hand in hand. That's why I think in this case the recent India UAE BIT is a good practice, because in that case the India government also has a very high loaded state favoring BIT, but it came to the practical terms and like listened to the investor and tried to not take a hard position on some of the issues that model BIT usually provides, like an absence of fair and equitable treatment standard, a very rigid MFN and national treatment standard, as well as no recourse to direct international arbitration, and a very stringent cooling period up to 5 years, which is also present in case of Nepal model BIT. And I think drawing from the regional experience, I think Nepal also can try to be flexible, practical, and try to align its interest. At the same time, not forget that the very purpose of BIT is to actually encourage the foreign investment. So I think that's something to look after in days to come from Nepal. And one issue that I also want to highlight in this landscape is the Public Procurement Act. So I understand from the Indian perspective, recently, India is being rigid in opting to arbitration in public procurement and bidding contracts. And why I draw Indian experience is because in Nepal too, there are a lot of bureaucrats and like people in the Ministry of Construction and development. Those ministry are also more and more inclined to drop arbitration from these, from public procurement and model procurement documents and bidding documents. And this is maybe because in context of Nepal, what I can say is this is because the Nepalese arbitration award rendered against state or are being susceptible to numerous challenges, not just at the high court level, but it also goes to Supreme Court level. In some case, even though the case are dropped, there's an increasing and a very bad practice to take recourse to the extraordinary remedies like repetition, which is a very bad and exercise, because that's not what the purpose of those remedies are. And I think drawing also from the Indian experience and also from Nepalese experience, what I can see is going forward, Nepal will also have very hard time, or Nepalese practitioners, Nepalese private practitioners, Nepalese construction professionals, they will have very hard time convincing government to have arbitration as the method of dispute resolution in the procurement contracts. And so what is also interesting is Nepalese Procurement Act itself prescribes the arbitration procedure, and that is coming into increasing scrutiny because of the numerous challenges. So that's the general overview of arbitration landscape in Nepal. So I think now in next slide, can we go to the next slide? I think in that slide, like I'll just deal with the Nepalese Arbitration Act 1999. So it's due to limitation of time, so I'll just deal on it on a high level basis. So it's the Arbitration Act 1999 is the governing legislation. So it is inspired by Ancestral Model Law 1985 version. So that's why some of the recent amendment that was introduced in 2006, like the recognition of interim awards and those kind of issues, are not present in Nepalese Arbitration Act yet. And then that act is also very rigid in that it has not been amended since a very long time. So it was only a year back when it was systematically amended, and in that time too, what I would say that those amendments were not very business friendly. Those amendments were not carried out in a manner that you would amend a 24-year long legislation, because I think those legislations are meant for practitioners, businesses, and those I think in that sense such kind of legislation should be shared. There should be consultation and there should be discussion, and that's how it should be amended. But unfortunately, it was amended via ordinance, and it is also tragic and comical because uh, while this ordinance was amended, there was a coalition government in Nepal, and those coalition government had absolute majority. So it was kind of unusual for a coalition and an absolute majority government to introduce a piece of amendment through an ordinance. So that's also the context behind the recent amendment, which I will of course tell in the next slide. And so in this so this is the basic arbitration act overview. So due to limitation of time, I'll not be dealing more on every aspect. So like you can see, there's a judicial role, so it has a very high involvement of high court. So high court is involved in the appointment of arbitrator if there's a failure among parties or disagreement among parties or deadlock among parties. Then there's also in the removal of arbitrator, and also funnily in the evaluation of the jurisdiction. So as you can see, like in some of the good arbitration jurisdiction, the contestation of jurisdiction is provided exclusively with the arbitral tribunal. So only if there's a manifest error in jurisdiction, then that subject is like to be decided by the court. But in Nepal, it's still not the case. So high court has a very high role in this. So one good thing about this legislation is it provides the very broad language to provide interim relief. So the arbitrator have broad discretion to provide those kind of interim remedies, I think, which is really important for a prospering arbitration process. And I think this remedy has been very helpful in cashing bank guarantee, in like foreclosing various kind of assets before the settlement of the arbitration procedure. And like it provides for both the appeal and enforcement procedure. Like it's a standard appeal and enforcement procedure, heavily inspired and incorporated a lot of terms from New York Convention. So it's a pretty standard legislation in that sense. So now I think we can go to the next slide, where so this is the ordinance that I was discussing about earlier. So so there are a couple of really innovative and really contextual changes that have been introduced by this ordinance. So one among them, which I find highly relevant and highly pro arbitration friendly, is the expedited enforcement of arbitration awards. So this ordinance also introduces expedited arbitration, but as we all know, like the modern arbitration, institutional arbitration do provide that kind of avenue, and like if you choose that rule, then you can use those remedies. So it was nothing new, but what it actually introduces new is the expedited enforcement timeline. So now the parties have option to actually shorten the timeline of enforcement, and I think really innovative and really helpful to actually sort down the cynicism surrounding around the arbitration. Because as you know, arbitration in our part of the world is like getting a higher scrutiny, because of course it was supposed to be a quick settlement, but due to numerous challenges one way or another, and due to lack of discipline in conducting of the arbitration proceeding, it's taking longer than anticipated. So that's why I think this introduction certainly helps in you know making the best out of the arbitration procedure. And another change I found really relevant is the recent changes explicitly says that you are not uh, you should not re-examine the evidence in the setting aside proceedings. So I think I know this might not be a very new thing for some of our colleagues and some of the participant, but I think due to lack of explicit provision like this kind of provision, there would be a lot of examination of evidence, and the court would flounder between one issue or the other. And I think this explicit provision in the arbitration act now will certainly discourage court from going into the evidence, and also provides comfort to the arbitral tribunal because and the parties, because they didn't opt for the tribunal to actually review and take it as an appeal of an arbitration award. And second is the finality of the award. So now the arbitration ordinance also has said that now that the once the award is rendered, it is final. Like now, this also sounds very obvious, but usually what happened in this part of the country is that once you had this award rendered, now the high court usually suspended the application because it anticipated the challenge, and then it only enforced it after the challenge procedure was decided. But now it's no longer the case. The prevailing party can simultaneously go for the enforcement, whereas the challenging party has to demonstrate these certain criteria before they can challenge the award, which is provided in the next slide. So if we go to the next slide, so like I said, there's no automatic suspension of the award enforcement now. And interestingly, the ground for suspension of those enforcement is by the opposing party is very high, and that is it should include the case of corruption, fraud, or a risk of irreparable harm. So now I think this issue, the issue of corruption, is like very pertinent in international arbitration. And like French court and the Swiss court have laid down numerous judgment, and the arbitrators are increasingly under pressure to investigate and resolve the issue of corruption. So I think I found it interesting, like because a country like Nepal has actually deemed that this kind of issue is relevant before suspension of award, maybe because like in this part of the world, like the allegation of corruption is too much frequent. So but what I think, even though this is an innovative provision, what I find a bit difficult to adjust is because it does not require any kind of security or financial guarantees during the suspension proceeding. So if you look at the countries like Japan or UK, it does not provide parties with the right to go on a fishing expedition to challenge the award. So you have to be serious, and you have to have that sense that if you don't challenge it in a way, like in a fair way, then you'll have some financial repercussion. So I think introducing some kind of financial safeguards would certainly mean that this provision would not be misused. But let's see how it goes. And second issue among this recent amendment is the standard of proof. So the ordinance lacks clarity on the standard of proof in corruption because, like I said, it's a new provision, and there are so many discussion and rich jurisprudence established by French Court of Cassation and the Court de Appeal of French Court, and also the uh, Federal Swiss Tribunal. So Federal Supreme Court. So they have laid down various standards like the prima facie evidence and the higher standards by some tribunals, which required clear and convincing evidence. And like some French court have also said that it should have a circumstantial evidence providing to us the certainty that the corruption was actually in place. So not as high as beyond reasonable doubt, but not as low as the civil standard of evidence. So there's always this tussle of what kind of evidence one should use in evaluating the corruption, because one, corruption is a serious offense, but then again a tribunal or a court is not evaluating a criminal obligation or a criminal liability. In that case, it is just evaluating whether there was a an award tainted by the corruption. So that's why this kind of standard is very really interesting in this context. But I think what Nepalese ordinance missed out is to actually have a say on this, what would be the correct standard. So I think this is something which will be fleshed out in practice, and let's see, like we'll have some clarity. So to the next slide. So now I'll just summarize like the key case laws that has been issued by Nepalese Supreme Court. So this case basically acknowledges that the law governing the arbitration agreement and the law governing the substantive contract are not always the same. And just because one party is party to the, so there's a substantive law governing the main contract, you should not assume that that also is by, in itself also covered. It is also covers the arbitration agreement. But I think this might seem like a very innovative judgment, but I think this is not actually helpful in a common law context, because if you look at Singapore courts, like if you look at English court in Enka versus Chop, they have taken a very practical approach and said that when a party has actually entered into the contract, you can't assume that unless there's a proof to that effect, you can't assume that they tried to, have different governing law. If they had intended, then they would certainly put that. But this judgment flipped that assumption and said that the parties will have to be, choosing those different law, and you can't assume that. And I think this creates a practical problem in defining what would be the law governing the arbitration agreement. And actually this case is very close to the civil counterpart of Kebabji and cloud food cloud in French court, where French court also had this similar provision. But bear in mind, French law has a very different standard. Like in defining the arbitration agreement, it says that the arbitration agreement is governed by international uh, public policy and international standard, and it's an autonomous. But since Nepal and common law takes a conflict of law approach, so I think this case is an interesting approach, very close to French approach. But I think it fails to look into the close connection test and those kind of tests that one could recourse to in finding out the law governing the arbitration agreement. So I think it will be interesting. So the UK has amended its law to make it clear. I think we should also do similar exercise just to have avoid this kind of legalese conversation, at least to businesses. So the next case in the next slide, I think this I think to our Indian audience in this panel and in this forum, like all to the attendees, I think this case is really really relevant, because in this case, basically what Nepalese Supreme Court said, which I think is rightly the case, but which was unfortunate, is that the Indian awards are not enforceable in Nepal. And I think I don't have to explain more, because as you know, India has a list of reciprocating territories, which is, I think, very surprising to me, because India is such an advanced arbitration jurisdiction with so many sophisticated case laws cited across numerous jurisdiction. But still, the Indian government maintains that reciprocating territories, and Nepal is not in that territories. So now, in this case, basically the Shanghai brothers got this award rendered in India, and it tried to enforce in Nepalese court. And Nepal has, like I said earlier, it has a reciprocity reservation. And since India will not recognize Nepalese award, so the Nepalese Supreme Court also upheld the High Court's decision not to recognize this award. I think this is, I don't know why this reciprocating gadget is still in place. I think we could do away with this, because at least from Nepal's perspective, because India is Nepal's largest trading partner. And I think if we are to promote this cross-border trade and commerce, I think we should certainly, you know, take out this kind of unpractical and unfriendly practices. But let's see how things will transpire. And the final case, so I don't want to go more into this. This is also a very erroneous judgment. It basically says that the if there is no appointing authority chosen by parties, then you have to go to the Nepalese court. Like, I think this is very erroneous, because as all the practitioners would know, ONCITRAL provides that default procedure for appointing authority. So does ICC rules and others, like they have that procedure. But now it says that you have to go to the High Court, I think, which is in my view very preposterous and impractical. So I think these kind of decisions are actually affecting the interpretation and belief of practitioners in arbitration. So finally, like let's to the next slide, please. So finally, this is my final slide. So basically, what I believe is the next step for a minnow country like Nepal, which has a lot to learn, but also which believes in arbitration as a means of settling dispute. So maybe we should have a clear law governing the arbitration agreement, do away with all this analysis and dispute, like UK did. Maybe we also should permit parties to waive the grounds for challenge, because that way party will be more motivated towards settling dispute through arbitration, and it will make it efficient and less susceptible to frivolous challenge. And third is, we should limit the court review of jurisdictional objection as much as possible. Maybe the inspiration is Swiss and French practice. And we should also have modern regime for enforcement of interim awards, though those issued by foreign seated arbitration, and also support the request for evidence from foreign seated arbitration award. And we should also recognize the emergency award issued by SIAC and others, because now arbitration is not just about after the constitution of tribunal. Arbitration is more and more also concerned about pre-constitution of tribunal remedies. And finally, like, we should also provide for arbitration legislation should also provide for joinder and consultation, which is more and more important remedy, because in context of multi-party arbitration, in construction arbitration, there's not a single party, and like the arbitration should now grow to include and absorb those kind of possibilities as well. So thank you for having me in this webinar and listening to me throughout. So if you have any questions, I would be happy to take it. Thank you.
Yes. Thank you, Sameep, for the insight on the Nepal in the perspective of investment arbitration, as well as the perspective of Chartered Institute of Arbitrators, Nepal chapter. It is a nostalgic feeling when it comes to the Nepal, particularly the Nepal institution. I think the oldest institution in Nepal, that is the Nepal Council of Arbitration, similar lines to the Indian Council of Arbitration. And if you can see the model of functioning of these institutions, being the very unique qualities of the traditional arbitration mechanisms, and it was acceptable, no doubt. But now the world is moving fast. The reforms, the acceptability, the judicial pronouncements, all are rapidly developing. And the good thing is that, as you rightly pointed out, as of now, Nepal has faced only one investment arbitration, wherein it's a good statistic for all of us to understand to what extent the applicability of this ADR mechanisms in the jurisdiction, particularly between the two giants, Asian giants, the one side the Chinese and the other side the Indian. That is a great opportunity what Nepal can provide, and your insight on it was wonderful informations. And thanks once again on behalf of KFCRI to have you on a late evening in Nepal, sharing with us. Thank you.
Thank you, everyone.